Okay, so I'm going to make a start now. Just to let you know that this webinar is being recorded. The slides will be sent out to you after the webinar, and Q and A's, if you could please leave it to the end so I can get through it all, that would be great. All right, so let's make a start then. So this webinar is what to do when a potential successor claims for unlawful eviction, or in circumstances where you can avoid it, basically. It focuses on the legal and practical implications of unlawful eviction of potential successors in social housing. But before I go into what we're actually going to focus on, I'm going to have to draw your attention to this note, because it's not intended as legal advice, but a general illustration of legal issues. Right, so what we're going to focus on this morning is what unlawful eviction is, and the key legislation, which is the Protection from Eviction Act, the consequences for the landlord, criminal prosecution, compensation, rent repayment orders, and then we'll go through the common pitfalls, succession rights, failing to serve notices correctly, some best practice, and instances where nobody qualifies as a successor. And then finally, we'll go through the civil remedies and consequences for landlords. So quite a lot to get through this morning. So what is unlawful eviction? It's also known as illegal eviction, and it occurs when a landlord takes matters into their own hands and removes somebody, not necessarily physically removes them, from the property without due legal process. It also includes depriving an occupier of access to all or any part of their home. And it will be a criminal offence to unlawfully evict a residential occupier if the landlord knew or ought to have known that they will cause the occupier to quit or refrain from exercising their right or remedy, a right or remedy under the Protection from Eviction Act. So landlords must follow formal legal procedures, serving proper notices and obtaining a court order before evicting someone who qualifies as a residential occupier. And if you don't do that and you evict somebody without following those steps, you risk criminal prosecution under the Protection from Eviction Act, which we'll just come on to now. The eviction without a court order can also lead to trespass claims, damages, and reputational harm. So examples of unlawful eviction would be when the landlord changes the locks while the tenant is away, physically removing a tenant or their belongings, using threats, intimidation, or violence to force a tenant to leave, harassment that is so severe it forces the tenant to leave, and cutting off essential services like gas, electricity, water, to make the property uninhabitable. There we go, sorry about that. So the Protection from Eviction Act offers legal protection for occupiers and is provided by Section 1, where it states that it's an offence to evict an occupier without a court order or harass an occupier of residential premises. We're not going to focus on the harassment in this webinar, we're just going to focus on eviction. And then Section 3.2 and 3b defines occupiers as residential occupiers to include tenants and licensees who have a legal right to occupy, and either through a contract like a tenancy agreement or a license, or through a statutory right, for example, under the Housing Act, and succession is a statutory right in some circumstances. So potential successors are, they have the right under that Protection from Eviction Act. The protection does not extend to trespassers who occupy without any legal right. So the key is the legal right. So if they don't meet the statutory or contractual criteria, as the case may be, they will have a legal right to remain in occupation, and possession must be sought and granted by the court, and the court will have no discretion to allow them to remain if you've done everything correctly as a mandatory possession. But note, an unlawful evicted occupier will be homeless and will qualify for assistance under the Housing Act 1996 from the local authority. So let's go through the criminal offence. It's contained in section 1, which we've just looked at. Anyone can be charged with an unlawful eviction or harassment. The act must have been committed with actual or deemed knowledge that they will cause the occupier to quit or otherwise refrain from exercising a right or remedy. And if performed by a limited company, a director or any officer of the company will also be guilty of an offence if it was consented to or conspired, or if they consented to or conspired to the harassment, or it happened because of their negligence. Criminal proceedings are initiated in the magistrate's court by the local authority, mostly. But if the local authority doesn't prosecute, it's open to the occupier too. And penalties in the magistrate's court are an unlimited fine or up to 6 months imprisonment or both at the magistrate's court, or if the landlord if the landlord has elected the proceedings be initiated in the Crown Court, which it can be, there's an unlimited fine and up to 2 years or both. So the defence for a landlord is contained in section 1(2). The burden of proof is on the landlord, and they must have believed and had reasonable cause to believe that the occupier had moved out of the property, they ceased to reside in the premises. The Power of Criminal Court Sentencing Act 2000 provides that compensation damages can be paid for loss and damage resulting from the offence. So it includes ascertainable losses such as damage to property, time off work, costs of overnight accommodation, eating out, etc., and shock, distress, inconvenience and discomfort, but it doesn't provide for loss of the home itself. There's no limit of the compensation for adults, but it's limited to £5,000 for under 18s. So rent repayment orders were introduced by the Housing Planning Act 2016 for offences on or after the 6th of April 2017. And the application is by the local authority or an occupier to the first tier tribunal. And the tribunal must be satisfied that landlord committed the offence. There's no need to prove prosecution or conviction. There's no need for a prosecution or conviction. They just need to be satisfied that the offence has been committed. The landlord can be ordered to repay housing benefit or universal credit received in respect of a period up to 12 months before the date of the offence. So common pitfalls. Landlords often, we'll go through the succession rights. A lot of landlords do get it wrong, make mistakes where they don't basically follow their policies and procedures sometimes. But it's hard sometimes because it is quite complicated with the changes with the Housing Acts and everything else. So mistakes are often made, and lawful occupiers are often considered trespassers, but you must get it right for a potential for a claim for unlawful eviction is going to be imminent. But I'll take you briefly through the legal framework of succession rights. Joint tenancies and survivorship. None of the statutory provisions governing succession actually apply to joint tenancies and survivorship. And on the death of a joint tenant, the tenancy actually devolves on the remaining tenant under the right of survivorship, and that was provided by Solihull and NBC confirms this, and Hicking 2012. But note under section 88(1)(b) of the Housing Act 1985, where this happens, this will be considered a succession for the purposes of the Act. Even though it's not a statutory succession, it is considered a statutory concession. So the key legislation we're looking at with succession rights is the Housing Act 1985 for secure tenancies, Housing Act 1988 for assured and short-hold tenancies, and the Localism Act, which basically amended both of those acts, and there's rules separate for pre and post the 1st of April 2012, and that's where the confusion comes in. I'm not going to actually go through the rights because it would be a different webinar altogether. But practical advice and practical advice and best practice for landlords when they are investigating succession claims from occupiers is to basically carry out a thorough succession investigation, review the tenancy agreement and assess the residency and family ties for succession claims, and look at the full context. Engage sensitively because many of the occupiers will be grieving and feel quite vulnerable. Take early advice to mitigate risk and avoid premature legal action. Transparent communication, clear and open communication with potential successors, put my teeth back in, builds trust and ensures fairness, and engaging with potential successors, it basically fosters trust and compliance. And then, of course, you need to implement fair practices to reduce legal risks and support housing policy compliance. You must use your internal policies effectively and ensure that tenancy agreements and succession policies are up to date and consistently applied. Okay, so the next common pitfall is where there is no statutory successor. A tenancy can be inherited when the remaining occupant is not entitled to succeed under the statutory succession rules, and steps must be taken to regain possession. Failure to serve legally compliant notices to quit leads to a defence to a claim for possession, and the requirement for notices to quit to be of a minimum period and be in writing. So when no one qualifies as a statutory successor, the tenancy will still be inherited, and that can be inherited under the tenant's will and by intestacy when no will has been made. So the role of the public trustee, if the tenant dies intestate, the tenancy vests in the public trustee until letters of administration are granted. The public trustee holds the tenancy in trust for the next of kin, who is entitled to the estate as per section 46(1) of the Administration of Estates Act 1925. And if you fail to serve a notice to quit correctly, which could mean only serving on the public representatives of the deceased tenant or failing to serve on the public trustee, that legal requirement will not, under section 18 of the Law of Property Miscellaneous Provisions Act, will not be met. So you need to serve the notice on the personal representatives at the deceased last known address and send a copy of the notice to the public trustee. Now, Gateway Housing Association and Ali basically states that the Court of Appeal clarified that the notice takes effect when served on the public representatives, but it will be invalid if a copy is not served on the public trustee before the notice expires. So it's very, very important that you do send the notice to both the public trustee and the personal representatives at the same time. It usually is done at the same time, but sometimes people forget. And if it has expired, the notice will be invalid. That's something that not everybody knows. If you want, I'll go through the actual case. Mr. Ali was a tenant of a house under a weekly periodic tenancy. It was granted by Gateway Housing Association, and during his lifetime, he enjoyed protection as an assured tenant. Following his death in August 2018, the tenancy lost statutory protection, but continued as a contractual tenancy until it was validly terminated by 4 weeks' notice to quit, ending on the last day of the weekly tenancy period. Gateway attempted to terminate the tenancy by a notice to quit, requiring possession to be delivered up on the 12th of November 2018 or later, a day on which a complete period of the tenancy expired. And the notice was sent by first-class post, addressed to Mr. Ali's personal representatives at the property, and was deemed served on the 17th of October. A copy of the notice was sent by Gateway by first-class post to the public trustee on the 18th of October, which was the day after, but only received by the public trustee on the 30th of October. Now, the Court of Appeal, the decision allowed Gateway's appeal, and they held that the notice took effect to determine the tenancy on the 18th of November, 4 weeks after the notice was served on the PR at the property in accordance with Section 18(1). The fact that the copy of the notice had not been simultaneously served on the public trustee under subsection 18(1) did not affect this conclusion, providing it had been received by the date the notice was stated to take effect on. Okay, so let's have a look at inherited tenancies and the implications for landlords. If the remaining occupant has inherited and lives in the property as their only or principal home, you can't just serve a landlord, you can't just serve a notice to quit. You have to serve the appropriate statutory notice, Section 8 or Section 21, as the case may be, and initiate possession proceedings under CPR 55. So I would encourage landlords to act promptly in respect of inherited tenancies. Oh, sorry. Have I gone back? There we go. Sorry. And seek legal guidance when dealing with inherited tenancies. So imagine the tenant passes away and the person left in the property isn't a statutory successor. What happens next? Well, we've just gone through the inheritance. If it is inherited, you will use mandatory ground 7, death of tenant, and of the Housing Act 1988, and you can seek possession if the tenancy passed under a will or intestacy and proceedings are started within 12 months of the tenant's death. Missing the 12-month deadline doesn't necessarily preclude you from making an application for possession. You have to apply to the court for discretion, and they will allow proceedings to begin within 12 months of when the landlord became aware of the death, not the actual date of the death, if you can persuade them to do so. Or alternatively, you can use the other grounds for possession, the discretionary grounds, rent arrears, antisocial behaviour if they're available. And if the occupant doesn't have succession rights, the landlord may offer a new tenancy or negotiate a voluntary move out. And I would also, again, recommend seeking legal advice to explore your options, because it can get a bit sticky. Right, so civil remedies and consequences for the landlord. So remedies for the occupant, civil consequences for the landlord. Proceedings are brought in the county court unless the value of a claim is above £100,000. Then the occupant can elect to bring them in the county court or the High Court. Like I said before, occupants can apply for legal aid for claims for injunctions and damages, and action can be brought quickly if it's an emergency, and emergency legal aid can be granted in that respect too. So we'll be looking at injunctions and damages, and contract and tort, and statutory torts. So injunctions, an occupant will seek an interim injunction to maintain the status quo pending the trial, for continued or reinstatement of occupation, and that is decided on the balance of convenience. And normally the cases are decided on the favour of the occupant who's been unlawfully evicted, but may actually be subject to an undertaking to pay rent pending the trial. So that's something that we can always ask for. And that is the balance of probability does actually tilt in the occupier's favour if the property is empty, but if it's relet in the interim, an injunction is not usually granted. The tenant has the right to bring a claim for damages as well, and I'll come on to that, the statutory damages, in a minute. So special damages are available. They're awarded at the end of the case, and special damages are specific sums for money and the same sorts of damages as referred to earlier that can be awarded in the magistrates court, and it includes damage to furniture, cost of eating out, overnight accommodation, lost property, etc. And then general damages are unquantified sums for shock, distress, injury, inconvenience, loss of right of occupation. Just a little note on the special damages is the rates. Case law suggests that the damages per night are around £200 per night, so you get awarded that much. But general damage is for harm, and there is an uplift on damages for all damages when they're claimed in civil proceedings, and that is an uplift of 10%. And that was actually to avoid no read and no fee conditional fee agreements, but it applies to all cases of damages, and that's the case Simons and Castle, which provides that. And then we've got aggravated damages, where compensation for injury to feelings of dignity and pride are available, or when the landlord has behaved particularly unpleasant or violent. And exemplary damages apply when the landlord profits from selling the property with vacant possession and so is unlikely to apply to social landlords, but it's there. So we're looking at contract and tenancy. A tenancy is a contract, and because an eligible successor takes the tenancy, there may be an express term for quiet enjoyment, and if not, there is an implied term for quiet enjoyment. So the landlord, by evicting them, will have breached contract. Trespass, however, is the most relevant tort relied on in civil actions for unlawful eviction. I was going to say universal credit then. And trespass, it's a civil wrong, and trespass to land is where the landlord enters without the tenant's consent. I'm going to call the occupied tenants interchangeably now, because they will have had a right to the contract. And trespass to goods is basically unlawful interference with goods, even if the eviction is unlawful, and it includes disposal, removal, or even leaving them outside. And in terms of goods, action can be taken by anyone who owns the goods, not just the occupier or tenant. It doesn't depend on rights regarding the premises. Just a little known fact there. So you might not just have the occupier claiming trespass to goods, it could be their friends, their family, if you've removed anything of theirs. Statutory torts are provided by the Housing Act 1988, and Section 27 provides for the specific tort of unlawful eviction, and it's the same definition as that as the criminal offence under the Protection from Eviction Act, and it can be committed in two ways. So unlawful eviction or attempted eviction or harassment. The defence mirrors the criminal defence, and you will have one if you believe or had reasonable cause to believe that the occupier stroke tenant was no longer living in the premises. So an example of attempted eviction it would be where the landlord attempts to exclude the successor tenant by changing the locks. But if they're able to gain entry through a window, for example, that would be classified as an attempted eviction. Section 28 of the Housing Act 1988 provides for damages. The damages are calculated as the difference in value of the landlord's interest in the property, with the tenant still living there and having the right to stay, and without the tenant living there, as if they had no right to return. So this is called the diminution in value, and how much less the property is worth because the tenant had a legal right to occupy. The case of Loveridge and Lambeth, where we have a secure tenancy, Mr. Loveridge was unlawfully evicted by Lambeth Council. He had a secure tenancy which gave him strong rights to stay. The court assessed the value of the property, with Mr. Loveridge's secure tenancy worth much less because a buyer couldn't easily take possession, and without him, the full market value. So the difference was 90,500, which was awarded as damages under Section 28. So that is quite a significant chunk. And that was in 2014. So just imagine how much it would be now. But if before the court case finishes, either by agreement or by court decision, the occupier is allowed to move back into the property and becomes a residential occupier again, they can't claim the damages and there'll be no award under Section 28. So it's a no-brainer to give them the property back. So that brings us to about half an hour. So if you've got any questions, I'll be happy to take them. Have we got any questions? Happy to take them now. Okay, so a follow-up email will be sent to you with your contact details if there are any further questions. We're happy to assist. Just want to thank you for your time and to say have a lovely day. Bye.